Okay. Without further ado, I will call the first speaker of affirmative team, Nur Asmi. And it's yours.
Thank you for the chance, ladies and gentlemen. What we have to know that sexual violence prevention and handling task force is indeed a relatively new division in Indonesian universities as obligated from regulation of the Minister of Education, Culture, Research and Technology number 30 of 2021. However, ladies and gentlemen, too often we see cases of sexual harassment or assaults within universities handled quietly and intentionally without ever reaching a criminal courtroom. This happens because many institutions wish to avoid bad press or long, complicated legal processes. As a result, true justice is often set aside in favor of quick, behind-the-scenes settlements. But when we fail to prioritize criminal charges, we ignore the serious nature of these crimes and send the wrong message that these offenses are not a real offense. For the victims, of course, we believe that this approach is not on their side. They deserve not just acknowledgement, but real accountability for their attackers. By pushing for criminal charges, we give survivors the foundation that the law is on their side. It shows them that what happened to them was not a disciplinary issue, but a serious, punishable crime. It helps them regain their sense of dignity and control over the narrative, rather than feeling silence or pressure into quiet agreements. As a government also, we think that sexual violence. Yes, please.
If reputational backlash is the problem that it is likely still existing, there are the hospitals so far where it reduces the type of criminal charges that's going to be pursued by the university. So no downtime or something.
But we think that as government, sexual violence which happens in education institutions should never happen at first place. And when it happens, we do not only talking about reputation or whatever, it already all systematic failures that the education institution failed to preserve since the very beginning. That is a safe place to pursue education. Therefore, we think it's fair enough to bring the case to court through formal criminal proceedings to publicly condemn such behavior and to ask for accountability by the perpetrators by serving years in jail besides merely administrative sanctions by the university. And also for the task force, we think that prioritizing criminal charges sends a powerful signal. It shows that the entire university community that sexual misconduct will not be brushed aside, and it ensures that offenders face meaningful consequences and that the institution values justice over reputation and education. Before going to court, our disclaimer is that to prioritize pursuing formal criminal charges doesn't mean that it's an obligatory mechanism. Victims can still opt out to criminal charges options. However, the approach of task force will lead victims to choose criminal proceedings against the alleged perpetrators. Our mechanism is clear by these three steps. First, we believe that we will prioritize the criminal justice process from the start. Once a credible report is made, task force will immediately gather and secure all available evidence, and we will connect the survivor with free legal consultations that also are available free legal aid, and experienced lawyer who can guide the survivor through the process. And our team will also provide psychological support, ensuring that the survivor feels safe and feels heard during the process. Second, our goal is to not force the survivor, as we have previously disclaimed, but to earn their trust and consent to move forward with criminal charges. By working closely with law enforcement, we create a transparent system, definitely, free from hidden pressure or attempts to bruise cases under the rug. This means no required settlements that protect the university's reputation over the victims will be. And we agree that regardless, whenever the settlement behind the criminal courts or even in the courtroom, the rumors and gossip directed at both the victims and also the alleged perpetrators will occur regardless. But by pursuing official legal action, we give survivors a powerful tool, a formal, recognized platform that establishes the truth instead of leaving the narrative to the whispering throats. That's what we seek to pursue at the very first place. So, ladies and gentlemen, our arguments today is quite clear that why prioritize criminal proceedings will be based on like two major points. First, we think that this is a more pro-victim by uphold legal rights at the very first place. Second, we think that our proposal creates a much safer environment for the victims and the students overall. Talking about our first argument, we think that reporting cases of sexual violence to the police is a part of the right of legal services for victims of sexual violence, of the sexual violence law. Possible arguments that will come from the opposite side of the house might say that, first, the standard of proof in criminal cases is beyond reasonable doubt, making it harder to secure conviction in some cases of sexual violence, or possibility or defamations that fail to the victim by the perpetrators. We think that is not the discussion here. We think that what we try to pursue at the very first day is the survivors has right to report to the police. Whatever the consequences later will be taught and discussed at the later points. So, ladies and gentlemen, when cases are settled out of court, survivors often feel silenced and disempowered. They have taken the courage to step to report their experiences. No, thank you. Only to have resolution hidden in private agreements. This secrecy leads to the victim blaming rumors and the damaging idea that the victim provoked the incidents before they actually happened. In an environment where conservative values and old-fashioned standards still linger, this lack of transparency allows the blame to always shift back to the survivor, right? And it always discourages others from coming forward, fearing the same shame and isolations. But, ladies and gentlemen, importantly, there have been strong social movements pushing to shift the shame away from the victims and also onto the perpetrators nowadays, where it rightfully belongs. For small examples, there is a global movement, for example, Me Too movement, for example, that society we see support all the survivors to talk about what the sexual violence happened to them, and in real life, society in general definitely support instead of blaming them. By choosing like the dispute outside the courtroom means that we are being repressive towards this movement, definitely. And bringing this case of the court is not about sensationalizing the issue. It is about giving the survivor a recognized impartial platform for their voice. The legal system, with its established role of evidence and judges and more transparent procedures, offer a higher level of credibility than a closed-door meeting run by the university's task force. It assures that all parties are held to the same standard, regardless of their position or popularity. Second argument, we think that our proposal creates a much safer environment for the victim as students, because when we prioritize criminal charges, we do more than just provide justice to one single survivor. Therefore, we create a safer environment for everyone on campus. Thank you.
Thank you so much for the first speaker of affirmative team. Now we will call the first speaker of opposition team, Sri Rahel.
Mr. Chair, government side of the House can only win today's debate if they can prove to you, first, why pursuing or prioritizing formal criminal charges against alleged perpetrators can be mutually exclusive for the protection to the victims, assuming or in case victims do not want to pursue this to the court. Second, they need to explain to you why status quo is not enough, why prioritizing settling cases out of court or relying primarily on an internal administrative system is morally wrong. That government didn't prove to you until their last very seconds in channels. As we come and say to you that if this kind of process, if the victims do not want to pursue, then that is okay. We just want to pursue the perpetrators. But that is not what's going to happen in our current criminal justice system, especially in Indonesia. Ladies and gentlemen, in our trial court system, it's not happening that way. There will be a numerous trial cases in court that involve the victims' witnesses that will reopen the old one, what can bring back the trauma of the victims. I'm going to intertwine it in my substantive speech. Ladies and gentlemen, as the opposition, our main goal is simple. We want to place the best interest of the victim at the very center of today's debate. Victims of sexual harassment and violence face not only physical harm, but also deep emotional wounds that can last a lifetime. We must respect their needs and their wishes above all else. This means that we should not force a single approach onto every case. Instead, we must allow victims to decide if they want to pursue criminal charges or use the university's internal process. By offering both paths, we give victims the ability to choose what feels right, safe, and comfortable for them. And we think this is very objective. You cannot decide what their interest. This is not about making it easier for offenders, but it's about ensuring the victim's voice is heard and respected. When victims feel supported and empowered, they regain control over their own story. Providing options is not only about protection, it's also about granting authority and promoting healing for them. Our priority must be empowering victims by giving them the freedom to decide how their case is handled. This is the most important principle at stake in this today's debate that government did not explain to you. In my mechanism, is very simple. We want to keep the current system that we state that current status quo is already enough. Our first mechanism is that Satgas PPKS offers both options. If the survivors wishes to go to court, then they can go to court and they can proceed to court. But if they prefer internal resolution, we should fully support that as well. This approach ensures that survivors have the freedom to choose what is the best for them. They can ask for immediate actions like removing the perpetrators from campus or applying other administrative punishments. They also receive ongoing support services and protection for their safety and well-being. Second, it is important to understand that taking the case to the criminal court comes with heavy social consequences, ladies and gentlemen. We live in a conservative society like Indonesia, especially in our country, Makassar, where public opinion can be very judgmental. Sadly, people might blame or shame the survivors, harming their reputation and mental health. Even though there are efforts to shift the blame onto the perpetrators, the ancient stigmas are still there, ladies and gentlemen. We have seen real examples like the current case where the rumor and negative assumption towards the victims is still there. Be it she's rumored having an affair with the perpetrators and etc. These rumors spread really quickly, hurting the survivors even more, ladies and gentlemen. Third, with an internal approach, the university can act faster and more immediately, removing the offender from the campus environment. A criminal trial, on the other hand, is slow and complicated, with many appeals before final decision is made. During this time, the survivors may continue to face stigma and harmful gossip, ladies and gentlemen. Keeping the confidential option available helps protect the survivor's privacy and mental state. We can ensure a safer and more supportive process. Let's proceed to my arguments. First, why does the proposal harm survivors and ignore their autonomy and interests? Ladies and gentlemen, let us focus on the real impact on the survivor where we can always push for criminal charges. These victims has already been through severe trauma. Reporting what happened is already a big step, an act of bravery in the face of pain and fear. We believe that when we force them into a criminal process, we must understand that every step can make them believe that their terrible experiences, investigations, cross-examination, public hearings bring back the painful memories they have tried so hard to overcome. Each retelling can reopen old wounds, adding the fresh layer of distress, ladies and gentlemen. No one else can truly feel the survivor's pain. No one else can bear the emotional burden. Society, the university, and even our criminal justice system might show empathy and sympathy, but at the end of the day, the victim alone must live with the trauma. If the process becomes too long, too public, and too harsh, it places an even heavier weight on someone who is alone well-being. In a university setting, the problems get even worse because of power imbalances. Imagine a student survivor facing a respected professor or a popular coach as the accused perpetrators. The perpetrators may have strong network of supporters, friends, colleagues, and even the public who adore them might refuse to believe they could do wrong, ladies and gentlemen. This creates an environment where the survivors not only battling trauma, but also facing a wave of sympathy of the perpetrators. We must provide choices that minimize additional pain and allow the survivors to regain control of their life rather than forcing them into a one-size-fits-all that might break their spirit further. Second arguments. Why is our side better for the survivor and the Satgas University? Ladies and gentlemen, the Satgas School works better because it allows flexibility of the victim's healing process. Under the current system, the survivor can choose an inter-resolution that keeps the matter more private, protecting their mental health and reputation. This reduces the stress of public judgment and prolonged legal battles. It helps them move forward with their lives, focusing and recovering rather than endless court session ladies and gentlemen. For the university, the status quo is also beneficial. They can respond quickly. The core of our stand is simple. We want to give survivors the power to choose their path to justice. Forcing criminal charges, dragging them through the painful public trials, and bringing the trauma. We oppose the motion.
I'll spend 7 minutes with 45 seconds.
Right. I will call the second speaker of affirmative team, Mr. Guillermo. Time is yours.
Before I go further into my speech contains several things. First is that I want to explain you why this case even going to spread and also affect citizens and also the world as a whole, not only the victim itself. And I'm going to respond to some of their case, and then I'm going to present you my rebuttal, and then we're going to weigh the benefit that going to happen on my case. Okay. There is a saying that popular in our country, right, which states that criminal court should be the last resort to resolve a problem, right? This means that people who likely to resolve a problem by themselves rather than bring into the formal court, right? With several methods like, as an example, negotiations, right? As a mediations to resolve the problem. This is true to some extent, I would say, right? For the minor problem like family issues, right? Such as disagreements between people that were going to be physical, as an example, because they don't actually want it to be a big problem. If you're going to, there's this kind of things that exist in a status quo, right? But we say that this is totally wrong, where we face human rights violations, right? Such as an example, sexual assault, physical and psychological torture, and also murder, right? Fundamentally, right, human rights cannot be violated, cannot be denied, transferred, and also limited, right? So at this fundamental needs, human rights cannot be violated because it requires to be functioning. It requires for a human to function as a normal human being, right? So that's why when human rights violations is a must for the perpetrator to be punished by limiting their freedom to the society itself, right? As it is international agreement and also commitment, so the states has to and obligated to. Therefore, obligatory for this motion is to be just and resolved in a formal court, right? Because in the sort of attempt for sexual assault, right, is done, no thank you, by fully conscious adult to be solved outside the court. This is the grace of humanity, right? It's disrespect to human rights, right? The urgency is that every case that opposition would like to make in outside of the formal court, like we continue to make the society the great fundamental human dignity, right? The potential as human, as this human urgent, right, to see it as a normal problem. Okay, going to my rebuttals. Several things that have been said by the government, by the opposition side of the house, right? They say that, okay, the victims might have two options here, and then they were likely to face these options where it is outside of the court. And they're saying that, okay, it promotes healing for them, it promotes them to be not seen as a victims that caused this case in the first place, right? And they say that this option, that the victim likely chose these options that where they're going to stand, right? We say that it's not exclusive on your side. We say that the gossip does not really resolve only on your side of the house, right? The assumptions toward these victims not going to resolve on your side of the house, right? Going to my argument. My premise is really simple. We want we want the formal criminal charge to make it to the district court, right? Because the law is product of society, it's product of international society, right? We believe that incentive for government, in this case authorities and also formal judges, first to ensure international agreement to fulfill, second to protect their citizen, third to legally putting them, because they're going to be legally putting them in the jail, right? They will limit the perpetrator freedom, right? In case on the government, the opposition side, they cannot do that, of course. And fourth, perform good governance, which is a system like rule of law, right? It's making the law apply consistently and fairly to all the people in the world, to all the people in the states. And then, why we think that formal court is better to handle these situations in the first place? Because they have the capacity that universities, as an example, do not have, right? They have better professionals, they have better procedures, they have better performance, right? Law has been agreed upon by the overall majority of the people, including President, DPR, and MK, and the obligations to fulfill the international law, right? And the ideology of the country itself, right? So definitely, they will be going to be better, and whatever the way, rather than whatever the way they're going to use in this ops, right? Because no, thank you. Because they put their thought properly, they refute properly, they also revise it frequently, right? They made the sanctions that are comparatively equal to the damage that experienced by the victim itself, right? They make sure the justice is first for the victim and the family, like giving a prison sentence and also paying several monies, right? Different from the administrative way that they're even no power to punish them equally. They're making people protesting about sanctions that they've made, right? They're waking up the anarchism that people who actually damage property and causing loss to the uni, even the student itself, where they cannot enjoy even studying at university, right? There have been more efficient and effective way to deal with this case, since the separate institute from uni, right? They will be more focused on spending time, money, and deal to this case, because uni will be more focused on research and academic activity. And then there will be no And then there will be no surat keputusan dadakan from rector, right, to force you to go to home and study online, right? There's no scenario like that. Okay, the performance of the authorities and judges who make decisions are people who have made their life to study law and they spend their life to resolve criminal cases, right? It's true to say that they have experience, that they have experience in this field, right? They have better upper hand on investigating the situations, might more revealing some might better evidence for the victims itself, to support the victims, and better handling the victims, better communication, better rehabilitation, better respond to the victim rather than the status quo when they're disrespecting the victims, right? Securing the victims if maybe another backlash that would have potentially come for the perpetrators, right? Because they have police, right? And then neutrally, we're going to solve the case, right? Compared to the uni, who's probably going to resolve the case with the staff that probably have oknum in it, right? People related to the perpetrators, right? So, what are the way in here? The government side, no thank you, will have this impact. First, justice will be served for the victim and the safety of the citizen, and it will be ensured for the government side of the house. And second, it will create more opening cases that probably didn't have happened in university. University will more be respected because they have good image, because they have performed this first and fast decision making and tolerating in how small incidents, showing their care for the student itself. Thank you.
DPR spent 7 minutes and 10 seconds.
second speaker of opposition team, Zahra Nadia.
Creating a safe environment derives from the internal section of the university. Creating Satgas PPKS is the university taking accountability for all the sexual assault cases that happen, taking responsibility for all the victims, improving and enhancing the Satgas PPKS is the right step and the solution for this issue, not pressing legal charges to the perpetrators. This is what government needs to understand about our cases, right? But let me do one important clarification first, Campus. Internal problem solving in university is not a mere medication, right? There are laws, there are regulations on how you should administratively punish the perpetrators. You can fire them, you can give like a 2 or 3 years coursing for these lecturers, for example. Government needs to stop being dismissive and only saying that the only problem solving that happens under our side is medication. It's not that, so stop about that, right? But 3 major responses coming from our side then. Firstly, there's second speaker talking about how this harm humanity as a whole, but I don't get what is the sense of humanity to begin with. The first people talking about they want to serve victim closure, but their second speaker talking about the humanity as a whole. So what do you want to serve? What is your goal as opposition, as government to begin with? Two responses for this, right? Firstly, harming humanity is when we do nothing to help accountable these abusers. Our case is exactly the opposite of this. We create a safe environment in the university, which did not happen under the government, right? But let's take their case then, parents. Even if our punishment is not that severe as jailing them, for example, but the parameter of the casualty of the punishment is not seen from whether or not we put them in jail, but whether or not this creates a big impact in the life of these perpetrators, right? You can put them into jail, but they can still come back and be lecturer at the end of the day anyway. So what freedom do you actually take from these kind of perpetrators? But under our side, when we administratively punish them, when we hire them, we take their accountability as a lecturer, for example. They cannot be like this ketua lembaga, for example. Those things, for example, meaning that we take their rights we take their job, we take their rights, meaning that even though we do not jail them, for example, but it creates a severe impact in their life because they cannot go to another university and apply their job there because they're actually being severely punished under our side, right? But secondly, second respondent talking about serving deterrence. I think that what 3 responses for this. Firstly, what makes people stop to do a crime is not because how severe the punishment is, but how much it affects their life as an individual. Hence why lots of people become recidivists because they don't think entering prison will ruin their life anyway, because they don't think entering prison will harm their freedom as an individual, right? But secondly, what matters in the life of these perpetrators are their job, such as lecturer or the student, right? Scourging them and firing or dropping them out of the university is the most impactful punishment that can affect the way their life works. They cannot be accepted in another university, for example, and your life just stops there. But thirdly, in order to have this effectiveness, this is why we should focus on enhancing and improving the Satgas PPKS itself with people that is objective and actually capable in serving this kind of punishment for the perpetrators. In the worst case, it doesn't give the right punishment. I think that it just pushes us to create a more effective Satgas and providing a safe environment. Hence why Professor Farida, for example, will report Firman Saleh to the Minister of Education so that he can be stopped permanently in being a lecturer because he's an ASN and can only be fired by the Kemendikbudristek, not Unhas itself. Even if we don't give necessary heavy punishment like firing them, it's still a process where the case is still going and there are still possibility in inflicting worse punishment for these perpetrators. But last rebuttal then, talking about victims closure. I think that 3 responses for this. Firstly, victim closure is not determined from how severe the punishment is, but whether or not the victims feel fulfilled by the punishment itself. In this case, the prioritization should stay on internal sanction because the characteristic of this victim, which mainly students, don't want to be exposed in court. As long as the people get punished or even they give them like compensation money, for example, they feel fulfilled already and the victim closure is already fulfilled under opposition, right? To make sure there are no, but secondly, to make sure there are no intimidation that is happening, we always support the victim and there is always a third party that will always support like how this case
work and how the investigation work under the Satgas PPKS. But lastly, even if we don't search enough victim closure, it is still better on giving them internal punishment because we agree it's impacting for the job which matters the most, so the magnitude is still better under our side. But let's talk about effectivity again. I think that my contribution to this for my team is clear. I want to talk about why this is the most strategic prioritization. I think that let's talk about the characteristic of university and Satgas PPKS, right? Firstly, university have the most fight to handle what is happening within their staff and students. Hence why this should be the prioritization. But Satgas PPKS are formed for the purpose of creating safe environment and to serve justice to all victims and perpetrators. Internal administrative sanction is heavy. It impacts more on their career, whether they're a student or a lecturer, right? But this administrative sanction is created because it is the only way university can punish these people through scourging or dropping them out of the university, because you cannot give them legal sanction that can only be served by the court to begin with, right? This is important because we can ensure a safe environment where these perpetrators get punished in their most impact aspect in life, which is their job or their study. I think that it's important to note under our position that pursuing criminal charges means you deprioritize in punishing them with internal administrative sanctions, meaning you have to wait for ages for these cases to be accepted and handled by the authorities, right? The characteristic of pursuing charges is that you have to provide all the legal team for the case. You have to hire lawyers, for example, where it takes lots of funding. Instead of enhancing the internal effective, instead of enhancing the Satgas PPKS, you want to use all the fund for this to prioritize the formal charges. Even though they already bring like a such mechanism saying that there will be a free legal team provided, you still want to hire an expertise lawyer so you don't lose the case in court, right? Note that if the perpetrators are big figures, for example, which in this case is academician, they have lots of networking, they have lots of power, that can hire the best lawyer and the legal team in the country to win the case. So what is the power of the victim actually under your side? Because there is none. Then how is self-justice for everyone? I think that it's clear. We make sure all the perpetrators get their deserved punishment, and for the victims to get all the necessary help such as psychological support, for example, to help with their trauma, etc. Rather than spending the time to pursue formal charges, we use all of our time and fund to make Satgas more effective. This will by selecting people that can work objectively, creating a better administration so everyone can report any sexual assault costs can be solved quickly. Helping the process of internal investigation where you will help the victim to gather evidence and more information. Under all those reasons, vote for opposition. Thank
You LO spend 7 minutes 11 seconds.
Now we continue with the third speaker of affirmative team, Maria.
Scorpio Arteries audibly. I don't understand why opposition wants the victim only choosing how they want their case to be handled, as if they even have power in the very first case, no matter where and how they want their case to be pursued. They're living in a Disneyland as if anyone has their power, although it is very clear that they are a victim and they need someone to help them. That's why they go to Satgas, because they cannot handle it by themselves. Very proud to propose. Someone abuse, sexual abuse, so many essays around me. Eminem might not go to Unhas, but how did M spell the word rapper? R-A-P-E-R, and he leave a P, did he? I know you all heard about Chang Coms and 120 cases of sexual abuse, domestic violence, sex trafficking, and etc. And no one knows how many of it actually are proven guilty, because it's still alleged. And most importantly, how many did he already settle out of court for 2 decades, and so many victims that are going all around there. That's just an individual, someone who's just a producer, a rapper in an industry. And now we're talking about the university. Basically, we force the Satgas and all of those things to make sure that you are going to protect everyone in this university, hundreds, thousands of them. And that is why we, as a whole team, since the very beginning, want Satgas to do more, and that's why we want to prioritize going to court. But before that, yes.
Yeah, all of your benefits is contingent upon the criminal charges being proven to be true. You have not proven that anyway. So what happens in your side of the house when acquittal happens, probably the retraumatization is going to be far more impactful on your side of the house.
Traumatization is mutual, not even mutual, I say, evil and vile under your side. Why? You suppress their trauma by settling it out of court, exactly that the power imbalance, exactly because internal administrative sanctions will never have the same amount of effect that a person that has been sexually abused, mentally abused, has going to be when they see their abusers are going to prisons, when they see their abusers are going into being humiliated and getting the same amount of trauma that they have gotten when they're just getting fired the way that you guys want. I don't know why. There's no exclusivity to that. Everything will publicly also release. It is not like the Menendez brother case, Ted Bundy, or like Dahmer. This is why Kas's explanation is important when it comes to like less gossiping. Exactly because when opposition talks about only happens when you give no exact credibility and also like a quick response, like a direct response, and this person is alleged and we are going to proceed to court directly, instead of just like settling it out like 3 days and 4 days, and only like people behind the university are the one that are going to push the case into the public, and now the public knows everything. So we believe since the very beginning, effectivity, we won on that, and trauma-wise, this is even, we think it is also much worse under your side. This is why people always fight for better CGS as well, for example, because people only feels enough and automatically thinks of justice when they think of court. Like, all of the money for the court process, the pay for the therapy session, this is everything that Guy has also explained that's going to be there under our side when Satgas are doing more, and it's something that you guys basically have to answer at the end of the day. But moving on, Kasmi also has explained to you why the status quo is not enough, and I don't know why you guys keep saying that it is and not actually engaging with our case, because we already explained to you that the task force Satgas PPKS should do more, because the court is, they always say that right now in the status quo, the court is the last resort to go to, as if they can somehow handle a situation that is very much inhuman, and they have the power and capacity to do that when it is not that legal. Even if they say that, oh, there's going to be third party what? Obviously legal authorities, and that's exactly what we want. Legal authorities, quick, effective, there you go, put charges on him. We don't care whatever they say about, oh, they have connections and all of those things. These clashes that they're trying to put upon us, we think that Satgas is a whole, it's a bigger, like no matter who, like Firman Saleh, I don't care who he is or no matter what professor you want to name, when they go against Satgas, the logic is Satgas will have so much amount of power in comparison to a person, no matter how many connections that they have. You can go on.
Yes, Satgas does not have autonomy or independence from the internal bureaucracy of Ektora. Probably yourself, the House of Representatives have power to determine what kind of strategy exists before filing any formal charges, because that's the process of court. So yeah,
that's why Guy and Kasta has explained to you Satgas should do more. We should put more money on Satgas and use that money not to make seminars and whatever the fuck that they do, but actually do the right thing, and that is going to court, getting legal and protection and therapy session, and not just, oh, we're going to give you psychology help, and there's nothing over than that. Like after trauma, just go. Like even mental abuse, we all suffer from mental abuse here and there, and we are never healed. Imagine the amount of burden that you have to put on yourself when it comes to sexual abuse that is physically eating you up all day, all long. Sahra saying that, oh, just punish them by throwing them away, like fire them, right? In comparison, logically, going to prison is obviously the one thing that I want. I want Firman Saleh to rot in prison. I want a living hell out of him. I don't care. Like, I want him there, like, for assaulting multiple innocent people and ruining Unha's glory just because whatever the hell that he did, and making a shame out of everyone and making a huge this whole shebang on the Indonesia about Unhas and basically ruining. And that is why Rektorat and Unhas formed Satgas PPKS since the very beginning to make sure that when a case happens, it doesn't goes out blown out of proportion. But in the status quo, due to how Satgas works right now, due to internal settling, like cases out of court, now you get more time to we can chill it and let's talk it out, blah, 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 blah. Well, in our case, let's just go to court and finish it right away. We think that is a much better approach that we want to do. If we want to talk about progressivity as well, everything, everywhere in the world, every case in the world, victim blaming always happens, and all of what opposition have explained still happens. That's why formal court is exactly what we need, as Guy has explained, because society will take it seriously, right? Like when you see a news and it's like going to court, oh well, everyone now is going not to just hate Firman Saleh, but actually feel for all of his victims and actually take it as a serious matter instead of just a gossip or maybe that he's cheating behind the doors and maybe this mahasiswi is goda-godaing him and all of those things. We think that once things goes to court and justice is put upon them, that is exactly when everyone and the society will take care and care for the victims. Yeah, all cases of government has faltered to propose.
The uphold will spend 7 minutes 27 seconds.
And the third speaker of opposition team, Mr. Muhammad Nail, time is yours.
The cases of government Satgas House is contingent upon whether or not the reputational backlash exists. I would argue that this is symmetric because reputational backlash comes from the fact that there is internal politics that exists within the internal structure on your own university. So all of the benefits of the House only exist when Satgas are actually that altruistic in wanting to determine all of the policies or whatever criminal charges they want to pursue. It's contingent upon them being actually good. If they're that good, then all of the out-of-court settlements and all of the internal sanctions are probably going to be massive on our side of the House anyway, insofar when he got fired, insofar when he does not get any less meaningful charges. So, third case is if it's contingent upon reputational backlash, it's not symmetric. So what is the tipping point? And I think the tipping point that we prove to you and they don't explain at all is probability, i.e., justice in terms of the House is kind of black and white. There is that either he get proven to be guilty on legal court or not at all, which means that in cases where he gets acquitted, all of the charges of all of the court of public opinions actively get diminished insofar where there's a legal question of him not being guilty at all on the actual crimes. Insofar where in terms of the House retraumatization happens, that's because of acquittal being more likely to happen in terms of the House because they don't necessarily prove. Why? Assuming that all of the academician is so corrupt or they have political power in order to prevent themselves from being sanctioned on our side of the House, it's likely for it to exist in their side of the House insofar where they have access to media, for example, like Firman Saleh, or they have access to a lot of good legal representation simply because his academician has networking, simply because he was friends with someone when he was still in university. So in their side of the House, all the process is still left unproven in terms of the House, how you can get justice in terms of the House. So, what can we tell you then? I think prior to criminal charges, you still exist within the umbrella spectrum of the internal politics of the university. Because to determine what kind of criminal charges you want to push, or evidence gathering or whatever, you still need the sort of the affirmations from rector, for example. Because for those things to pass, you need to pass an official letter from the rectorate or from the university for it to be possible. I.e., you still are being fettered by rectorate insofar as internal politics means that charges, whatever it is that exists in terms of the House, gets lessened. So repression does exist, but I would argue manifest in the worst side, in worse ways in terms of the House. There are far more incentives for them to close down cases before going into criminal charges or just drop any evidence gathering for the sake of not pushing criminal charges, but transparency that they talk about not necessarily exists because the process of filing the criminal charges doesn't necessarily get transparent because criminal charges get transparent only after you file it. What do we tell you then? Even at best, cases do go into court in terms of the House, two things are still problematic, i.e., reputation that still exists to the degree of criminal charges to be less severe as a way to mitigate the backlash. But second, the process of gaining justice simply have much more bigger burden in terms of the House because criminal charges requires you to prove it beyond reasonable doubt, i.e., any sort of evidence that kind of mitigate the probability of whether or not this is true means that in terms of the House, victims have a lot more legal responsibility to prove their cases, which means that justice is less likely to be served. What is the tipping point that we give you? The tipping point that we give you is two things. One, on whether or not the probability of justice is bigger in terms of the House, because the prerequisite of any justice being meaningful is probability for it to be proven first. Because in terms of the House, justice is bigger in terms of the House because they go to jail. But do they go to jail? And that's the question that they have not proven in this debate. But second, third case is kind of cross-opinion, but we have court of public opinion, we have activism, access to media, or whatever. The problem in terms of the House, there is a detachment of accountability. That is to say that if Firman Saleh gets acquitted, university can just tell, it's the problem of the legal court, not proving them to be guilty. On our side of the House, insofar when internal sanction is the process of justice, you can't, the university themselves cannot necessarily push them away. Because for Firman Saleh or whoever it is to be proven guilty, and if they're not proven guilty, all of the blame actually goes to the university. So all of the check and balance, all of the activism gets a lot more powerful in our side of the House, insofar when it all goes to the university as opposed to their side of the House to legal court. Yeah, sure.
Talking about this probability, just like you said, due to the corruption and politics under the university, it's easier for perpetrators to go away.
What? Yeah. This is a problem of Satgas PPKS. So the debate is not about what the victim is going to do, what Satgas PPKS should do. So what happens on our side of the House, if you only say, they can just go to the criminal court themselves. So it's in our side of the House. The question is, what should the SOP of the Satgas PPKS look like, whether or not they should prioritize criminal sanctions, whether or criminal charges. That's the debate. I don't think you understand the debate. What's the tipping point there? I think the tipping point is that if everything else is symmetric, at worst on our side of the House, even if the manifestation of justice is smaller, probability of any justice to be served is more likely in our side of the House. When in their side of the House, justice is questionable insofar as the probability is far lower, therefore the chance of lower. So if justice is small on the side of the House, what's the tipping point then? I think the tipping point in our side of the House is the amount of emotional investment and efforts that victims has to go through in our side of the House insofar as their side of the House. So in worst case, Firman Saleh gets acquitted, the victims actively get retraumatized and gets less more damage because not only that the narrative is all gone because he was legally acquitted and whether legally acquitted, so there's no harm, there's no justice being served at all when in our side of the House, even if Firman Saleh still exists and go around, at least there's a semblance of justice that is being served, as opposed to in our side of the House when there's nothing at all. What do we tell you guys from comparative? I think comparatively what we get is two things. One, justice, even if the degree is smaller, probability is bigger on our side of the House, and so far punishment still exists. Second, you have much bigger overarching grip on social narratives and whether or not those manifest in better ways, because activism actively goes to university and make university accountable because there is no detection of accountability that exists in our side of the House. In that side of the House, university can point out at the court saying that the reason why Firman Saleh is acquitted is because of the failings of the court, not necessarily on the university themselves. So you actively get more safe spaces in on our side of the House, and so far the university themselves that have to be accountable if Firman Saleh goes out in comparison to the other side of the House, where it is all upon the legal court to make sure that Firman Saleh gets proven guilty. So what happens then is that on our side of the House, the prerequisite of justice is the process, not necessarily the degree of the benefit that they talk about. So in our side of the House, justice gets served, their side, no. Proud to oppose here.
Vice Speaker of Opposition Team, Zahra.
It's very important to note that the government team has missed so many points in this debate panel that it's sadly and it's very unfortunate for their team in the end of the day, right? I think that there are three major points that they need to address in the beginning of their PM cases but has never been proven until the end of the debate. Firstly, they need to understand that court bureaucracy takes months and this is very crucial for the victims because this type of crime should be handled directly and that only can work when we prioritize the internal sanctions and the Satgas PPKS to begin with panels. They never give you any cases explaining that even though the court process takes that long, that it's still worth it under their side and it's still very better under their side rather than prioritizing the internal sanctions. But secondly, prioritizing press charges means that you cannot play in both teams and say you want to improve Satgas also, right? When all your time and funding will go directly to press charges, providing a secure legal team, good lawyer, and etc. So I don't understand when Karika come under this debate and say that they want to improve the Satgas PPKS, that's their goal also under government, but they never given you any mechanism how they can like differentiate like the time and the fundings to also improve Satgas PPKS to begin with. But lastly, pressing charges means they will get immediately, but lastly, they always claim that pressing charges, meaning that they will immediately get punished in jails, but they have never given you any cases that proves, even if you don't get punished heavily in court, how then it's still fair under their side of the house, right? I don't think that there is any important cases that actually prove that their worst cases is still better under our case in terms of magnitude. But my first and the last speaker has proven to you panels that even if we only scores like the lecturer, for example, and not immediately firing them, but there is still a progress within the internal sanction because it is directly handled by the university to begin with, right? That is why the cases of Prof. Farida that immediately want to permanently like fire Firman Saleh is the process of the cases to begin with. But comparatively, if this case is bring to court and it's only alleged perpetrators and not the right perpetrators, or like the cases is not proven and or like the evidence is not enough under their side, it will never most likely serve any justice to these perpetrators and the victims. So what is the tipping point in this debate then? I think that there are two tipping points. Firstly, it's talking about internal power, and secondly, talking about how we can support the victim. But let's talk about the first tipping point, right? The internal power. Why internal sanction is more important than pressing charges panels? I think that it's very simple. This immediately affects their biggest privilege, which is the internal power they have in the university, right? When we prove like the Sanctions PPKS and we give them the internal sanction, they no longer get paid. They no longer have any title like lecturer or like leader of some lembaga, for example, because they no longer have any privilege inside the university. Comparatively, on the government side, they still have the internal power. They still receive money from the university. They still can come back and teach in FIB, for example, because the court does not care about these aspects because they are not an educational institution. Because they are not the university that wants to actually serve justice for like the students, for example, right? But second tipping point is talking about victim closure. I think that it's clear. Victim can see the tangible punishment when we give them the internal sanction to the perpetrators. When they see the perpetrators get fired, for example, they no longer see them walking around the university. They no longer see them teaching in classes. They no longer see them laughing with other professors, for example, because the life of these lecturers will also ruin just like what the victims want and need, right? Because the trauma is that big mass. If the government always talking about how big the trauma of the victim is, then you should support opposition exactly because of this matter. But what we have doing under opposition, I think that is very clear. Firstly, we have proof why we are not only supporting the victims, we will also serve justice for the perpetrators. Secondly, we answer our burden, saying that why is the most effective prioritization. And lastly, we answer our worst cases, saying that in the terms of magnitude, even though they don't get like put into jail, for example, but they still get harmed in the most important aspect of their life, which is their job as a lecturer. Therefore, under all of these reasons, opposition will win. Thank you.
Opposition replies 34 minutes and 2 seconds.
And the last speaker is reply speaker for affirmative team, Mr. G. Time is yours.
I think that our case is very simple. Just want to support the victims themselves, to support them by giving them psychological help, right, mental help, and to support them into going to courts, right, promoting a legal lawyer by actually supporting them to win the case, hopefully in the court, right? We do not guarantee you to actually win the case as a whole, and then we actually say something about humanity which they not understand, right? This attempt for sexual assault, right, by a cautious adult to be solved outside of the court is actually a disgrace of humanity, right? Because it fundamentally needs for human to function as a normal being, right? So the urgency of the upper case that opposition made outside of the court itself is continually make society degrade these fundamental values. Right? Easy. This potentially causing human to see this as a normal problem, promoting more sexual charges, promoting more violations against human rights, right? Because it's just there's no integrity on these kind of things, right? You see it as a family problems as an example, right? You want to solve it under your terms, right? It's easy because it will create more problems like this in the future, right? On our first case, right? Even if it takes months, even if actually the Firman Saleh itself does not have the sanctions that he need, that he would take, right, that he deserves it to be, right, we would actually create more better work. Why? First, right, it would open more cases that probably happening in the university itself, because these investigations happens outside of the uni, right? They investigate our uni. They investigate more things that were happening without actually the victim reporting to Satgas PPKS as an example, right? It would create more cases. It would open up all the covered cases by the universities, the corrupt universities, right? Then this act, right, as an example, the whole case would not cause any damage to university, right? Because the time, the money, that would actually, the mindset of the oppositions that would make it really quickly because they love their monies, right? And they love their times, right? We actually have more support to these victims, right? University will see it as a respectable being, having a good image because they are firm and fast in making decisions for it to go to the court, right? For it tolerating however small the incident is, you have to take it to the court, right? Because it was going to be, you're going to glorify the human rights, right? And in their case, the university, if their worst case happens, will seen as a university that has failed to sanction their perpetrators, their docents, as an example, right? So strengthening integrity of human rights is more important, I would say, right? As a form of fundamental human being, so we make our society to be more fearing to a law, hence reducing the human rights violations that happen, right? What are the cases that would happen in the opposition side, right? The human rights law will lose its essence as a fundamental law that makes a fully functioning human, right? If you quit doing this outside of the court's operations, right? In every instance, it would make people to take the same idea of, oh, human rights is not essential, right? I can just assault anyone, right? No offense. And then the victims, right, in the end, will not receive justice as they are obligated to have. And the second, victims will not have a mental care because they will not be taking care of the professionals that we have in our side of the house, right? Victims will not have a better security for what can happen if the perpetrator actually want to revenge or whatever, right? Uni would not have faced the damage, right, that would happen if and not have such as time and energy be wasted for this kind of things, right? Because we're just going to force it to the court, right? So that can not result it in any backlash that would happen. I think that's it. Thank you.
And that's